The Supreme Court has decided to refer to Constitution Bench the petition challenging the validity of Constitution 103rd Amendment, which introduced provision for reservation to economically weaker sections or EWS. Economic reservation in jobs and education was proposed to be provided by inserting Clause 6 in Article 15 and 16 of the Constitution through the amendment passed by the Parliament in January 2019. The newly inserted Article 15(6) enables state to make special provisions for advancement of any economically weaker sections of the citizens, including reservation in education institution after amendment was notified by the President. A batch of petitions were filed in the SC challenging the constitutional validity of economic reservation. It was on July 31, 2019 that a three-judge bench reserved its orders on demands to refer pleas challenging the introductions of the quota for economically weaker section to a constitution bench. The legal question was, can the reservation exceed 50%? Can there be a reservation exclusively for the economically backward? These are the points which raise substantial questions of law. The bench was hearing a string of petitions challenging the validity of the EWS quota introduced by the 103rd Constitutional Amendment. One of the primary contentions of the petitioners is that the additional 10% EWS quota surpasses the court-imposed upper limit of 50% on reservations, 50%, 7.5% and 27% already standing allotted to the SC, ST and the OBC respectively. The Tamil Nadu Assembly had passed the backward classes, the scheduled castes and the caste scheduled tribes reservations of the seats in educational institutions and appointments or posts in services under the State Act of 1993, maintaining its reservation at 69%. The statute was subsequently added to the 9th schedule of the Constitution to exclude judicial review of it. The Right to Free and Compulsory Education Act also grants 25% reservation to the poor under Article 21A. The 103rd Amendment was nothing to do with the draft Constitution. Indra Sawhney noted that there could be exceptions to the 50% rule, thus catering to the educational needs of the poor in pursuance of the DPSPs not qualify as an exception, he suggested. AG buttressed this submission with the recent decisions of the Bombay High Court upholding the quota to the socially and educationally backward Maratha community. Justice Bobde has commented that the classification as minority was irrelevant as all communities have a section of poor.